Okay, so in this episode, we are going to talk about the National Venture Capital Association suite of model documents. And before just diving right in, I think it's useful and helpful to get a sense as to where these things came from. So as we know, anytime that you are engaged in a venture capital financing transaction, and frankly, almost any business transaction of any sort of size or materiality, you're going to have some kind of term sheet. Sometimes called a term sheet, sometimes called a letter of intent. It could be called a summary of terms, a memorandum of understanding, an indication of interest. These are all synonyms. And basically refer to a document which tends to be high level, more business language and expressed in business terms than legalese. But the idea is, before we take this transaction that we've been negotiating and kicking around and we translate it into the full set of definitive legal documents, in other words, release lawyers to go work on these and negotiate these, let's make sure that at least at a business level, we've got alignment around the core issues. So a term sheet can be 25 pages, 30 pages. A term sheet could be a bullet point in an email. There's no necessary form or structure or format to a term sheet, but it needs to express enough so that the lawyers have something to go by and so that the business people can be confident that what the lawyers bring back is going to be consistent with what the business people want. So when you look at a term sheet for a traditional venture capital financing, there are lots of issues that are covered. So as we know, you are selling preferred stock, or the investor is buying preferred stock, so you need to describe the preferred stock. Is it participating or non-participating? Does it have dividends, and if so, are they cumulative or non-cumulative? What are the board rights? What are the voting rights? Are there redemption rights, sometimes called put rights? Are there pro rata rights, sometimes called preemptive rights or participation rights? There are other issues relating to information rights or registration rights. Drag-along rights. So we've seen these and talked about these in other places and at other times, and we'll get into it a little bit more in this episode as well. But it's just a big pile of laundry. And these different issues can show up and be instantiated in legal documents in all kinds of different ways. And in the early days of venture capital, and let's call it, the 70s and the 80s, and even into the 90s, every law firm had their own approach. So if you are representing the venture capital investor, you are typically going to be responsible for not just drafting and presenting the term sheet to the company and to company counsel, but you will be responsible for drafting the documents. And you will use the sorts of documents that your law firm typically uses or that you personally use in other transactions. And what that means is you have this laundry list of items that we've just discussed that show up in the term sheet, and you have a way of sorting them. So you might look at it and say, okay, well, we have the certificate of incorporation called the Certificate of Incorporation in Delaware. If you're in another state, Articles of Incorporation. But this is where the preferred stock terms are going to be set forth. So we're going to put those terms there. And then maybe you say, we're going to put all the board provisions here. And we're going to put all the redemption provisions here. And we're going to put all the pro rata rights here. So you put those there. This is your certificate of incorporation, and a lot of times people will use the acronym COI to refer to that. And then maybe your law firm form has a stock purchase agreement. Well, what shows up in the stock purchase agreement? Well, this is the basic document by which the logistics and the technicalities related to the transaction are laid out. So who are the parties? Who's investing what and when are the closings, those basic, who's delivering what, those basic issues are going to show up in the SPA. Let's just call it logistics. But then you say, this is where the reps and warranties are going to be. That's short for Representations and Warranties. This is where the company is saying, as of this date, this is what the company looks like. This is the state of play. We own these things. We're in this particular position. This is our intellectual property. These are the contracts that we're party to. All of those reps and warranties show up someplace, and in your law firm form, they show up in the stock purchase agreement. And those are there to give the buyer assurance, the investor assurance, that they're getting what they think they're getting, so that they're not surprised. And they augment and supplement the due diligence work that they're doing in connection with the transaction. So this is what we have in the stock purchase agreement at this point. But maybe for this law firm, they also say, you know what, this is where we're going to put information rights, the kind of rights that the access to information that the investor has moving forward. And maybe this is where we'll put registration rights. And then maybe they had something called a stockholders agreement, which was just, frankly, a generic cleanup document. And in the stockholders agreement, we'll just call it SA, this is where everything else is. So, right of first refusal, it would represent a restriction on the founder shares and their ability to sell those, right of first refusals. That would appear in the stockholders agreement. Maybe this is where we also, maybe talk a little bit about the board. That shows up in the stockholders agreement. Maybe there are additional voting issues that show up in the stockholders agreement that weren't picked up in the certificate of incorporation. And that's the way this law firm did it. So they draft these documents based off of the term sheet and then present these documents to company counsel. So now company counsel receives these documents, and company counsel needs to do a couple of things. They need to sit down with the term sheet here, and then the documents they received here, and they just need to run through a basic checklist and try to identify, in an annotated way, where do these different provisions show up, because they don't know. Because they have their own document set and their own ways of doing things, and inevitably there's some overlap, but there's some difference. So they may go through and say, okay, let's see, we usually put the pro rata rights in the stockholders agreement, but okay, they're in the certificate of incorporation in this transaction, so that's where we need to look for those. So that takes time. So just to sit down and figure out what is where, and is everything covered, and is anything missing? So that takes some time and effort. And not only does it take time and effort, sometimes people feel a particular way about certain provisions. So maybe the company counsel typically puts pro rata rights in the stockholders agreement, and they feel really strongly that that's where they belong. Well, when they go through and revise these documents, they're going to yank the pro rata rights out of the certificate of incorporation, and they're going to move them into the stockholders agreement. So now they're going to show up down there. So when they go back to investor counsel will have to say why did they eliminate pro rata rights? That doesn't make sense. We had those in the term sheet. And then when they get to the stockholders agreement, say, they appear here. Again, there's just friction, there's interaction, there's time and energy spent on that. Number one. Number two, not only does every law firm have its own way of structuring these transactions and organizing these materials, but they also had their own pet language. So this law firm had a way of describing redemption rights and articulating redemption rights. This law firm has a way of articulating pro rata rights and saying them a specific way and putting the provisions in a certain order and having the flow go in a certain manner. That's going to be different than the way company counsel normally does it. So not only does company counsel, when they receive these documents, not only do they need to go through and make sure that everything showed up, that they expected to show up, they have to read the documents from top to bottom, word for word, and go through and familiarize themselves with the language used by investor counsel and make sure that the language adequately covers and encapsulates the point, doesn't run too narrowly, doesn't run too broadly, doesn't leave something out, doesn't say too much, expresses the point precisely, and inevitably there's going to be some friction around that, some disagreement around that, and lawyers being lawyers, this is what lawyers are trained to do. Maybe they're going to find a little bit more friction and a little bit more point of disagreement than even the normal person would find. So what happened was, it would take a while for investor counsel to prepare these documents. They would send them to company counsel. It would take a long time for company counsel to get to these documents, lots of internal grinding, and then they revise the documents, so maybe move some provisions around, change the language for sure, probably in meaningful ways in places, and then they send that back to investor counsel. So now investor counsel has to go through a parallel version to what company counsel did. Okay, where did they move things around? Okay, they changed the language. Why did they change it? How did they change it? Why did it go this way? Well, what you find is, and what participants in this industry discovered, was that it could take you a month, 2 months sometimes, to actually get to documents that were pretty close to completion, that adhered to the term sheet, covered all the points in the term sheet, and that were expressed in language that both investor counsel and company counsel were generally aligned around. And so once you got through that initial month or 2 month period, then they could actually get into the basic details, maybe where some of the material negotiation points are, sort those out, and then close the transaction. As you can anticipate, anytime you're dealing with lawyers who bill by the hour, and you're talking about spending time on these sorts of matters and issues, it's expensive. And there was a sense that for transactions which oftentimes are relatively small or small-ish, the legal fees associated with these transactions were out of proportion. So it's one thing to pay a lawyer X amount of money if you're doing a transaction that's $1 billion transaction. But if it's a $2 million Series A, you hate to be paying company counsel a lot of money and investor counsel a lot of money. And so there was a sense that the legal fees were just way too big, and a lot of it was associated with this churn. So folks started trying to solution around this. And in particular, the NVCA picked this up. NVCA is an acronym. It stands for the National Venture Capital Association. And they assembled a group of lawyers, subject matter experts in the field, and the idea was, can we come up with some model documents that represent middle-of-the-road transactions? What does that mean? They're not heavily investor favorable in terms of just being aggressively hard on the company, but they're also not so company favorable that investors will say, it's way too light, that's inappropriate. We want to find something that's middle of the road. And what the National Venture Capital Association did, with the help of these attorneys who served this process, was they developed these model documents. And these model documents are available for free on the NVCA website. So you can go to nvca.org. There's a section called Model Legal Documents. You click on that, and these documents all appear. And now they've been iterated because at this point they're around 20 years old. But surprisingly enough, the industry and lawyers themselves actually adopted these forms. So there was a sense that lawyers wouldn't do it. Lawyers are very particular. They have their own way of doing it. By analogy, I would tell you that the American Bar Association and other sort of organizations like that have tried to do these sorts of things in the M&A arena with stock purchase agreements and asset purchase agreements and merger agreements, and it just hasn't taken. They are useful as guidelines. Lawyers will use those forms to sort of point to and say, hey, this is what's expected, this is normal, this is market. But they've not been adopted as the form that everybody uses when they're doing an asset purchase transaction. And frankly, the NVCA, I'm sure at some level thought that might happen here, but at the very least, at least they're out there as some kind of market representation, a North Star, so to speak, that the lawyers could point to and hopefully clean out some of the noise that's otherwise taking place in the negotiation. But best case, the industry would actually accept them. And that's what's happened. So the NVCA model documents are in fact the gold standard. And for all intents and purposes, 99% of attorneys who practice in the space use the model documents. And the model documents do two things of critical importance, and they both go to the inefficiencies that I was just describing. The first is the model documents have a very specific architecture. And we'll go through those in a moment, but there are a specific number of documents, and each document does a specific thing. There's no moving provisions around and wondering where things show up. Everybody knows. If you're looking for pro rata rights, you're going to find those in the investor rights agreement. We'll get into that in a minute. So number one, architecture. Number two, basic language. So it's not just a set of documents filled with headers. You know, it's actually full-fledged legal documents with legal language expressed. So a pro rata rights expressed this way, information rights expressed this way, registration rights expressed this way. And there's a sense that it's good language, it works, may not be perfect, but it's good enough. Every law firm, every lawyer does have a little way that they like to tweak the language here and there. You find that a lot. But it's one thing to have somebody tweaking language. It's quite another thing to get a document set back with masses blocked out or masses added. And we've gotten away from a lot of that. So the bottom line is we have a month or a 2-month head start when we do these financing transactions, because Investor Counsel can take the NVCA model documents, sit there with the term sheet, change the model documents only as necessary to accommodate the specific terms of the term sheet, send those over to Company Counsel, and Company Counsel, number one, knows where everything is, so they don't have to hunt around and see if things have been covered. And Company Counsel probably is very familiar with these documents already, and they don't need to read them word for word because they've done that before and they're comfortable with these documents. So what they're looking for now is deviations. Okay, where do these documents deviate from the model documents? And you know, we have technologies and tools that help that. We run red lines. And so you can just sit down with a red line and you can see where the changes are. And you can say, okay, was that change associated just with adapting the document to the term sheet? Looks like, you know, purchase price per share is $1. That shows up as $1. That looks like a change in the form document, but we expected that. No problem. You go through and you see, oh, wait a minute, they changed this sentence. Why was this sentence changed? Well, maybe for good reason, or maybe not, and you can decide if you want to negotiate that or not. But what happens is that we've advanced the ball significantly down the field, which saves time and saves money. It has been a rousing success, and it works incredibly well. It makes these deals much more efficient. It makes them much less full of friction. It makes them much more cost-effective and less costly. And you know, psychologically and emotionally, one of the other things that it does is it helps maintain alignment between investors and companies. Because one of the things that's interesting is when you're selling a company, let's say an asset purchase transaction, for instance, the buyer and the seller aren't necessarily going to be working together in the same sort of way moving forward. You know, some people from seller may cross over and work for buyer moving forward, but for the most part, it's seen as being a black and white transaction, us versus them, pretty binary. And you can go at each other hammer and tongs. You don't really want to do that in a venture deal, because yes, it's, you know, arguably adversarial right now when we're looking at negotiating the documents and negotiating the deal terms and preparing the way for the money to flow from the investors to the company. But once the funds have hit and the transaction's closed and the deal is done, the investors and the company are on the same side of the table. The investors are invested in the company, they're friends. So what you don't want to do is have a transaction where the investors and the founders, for instance, are very excited to work together, but through this excruciating document production process, they come to hate each other. And there's acrimony introduced, and there's a lot of bad feeling that it gets pushed and poisons the waters in these transactions. And so to the extent that we can eliminate that or reduce the probability that it happens, as lawyers, it helps us be more successful in making these transactions move forward, not just in the moment, but preparing and setting this up to be a successful relationship moving forward. So that's prelude. That's the basics as to what the history is and why we have these and why this innovation is truly so radical and it's been so remarkably successful. So with that behind us, let's actually talk about the documents themselves and look at what the taxonomy is and the way that the NVCA has laid it out and why. So we can start with the Certificate of Incorporation. Now, the Certificate of Incorporation, I would contend, is the most important document of all. And it's the most important document of all here in the context of a venture capital financing because it's the most important document of all within the context of the corporation itself. The Certificate of Incorporation, when originally filed, actually breathed life into this entity. It's what created it. It's the charter. It's the Constitution. And when the company was originally formed, when it was originally organized, its original Certificate of Incorporation was probably quite short. It was a form that they downloaded from the Delaware Secretary of State's office or from some other service or from a law firm which created a form, just a couple of basic issues, boom, 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 done. 1 page, 2 page, very short, very abbreviated. Well, the Certificate of Incorporation now will be changed. Now, you heard me say something before about amended and restated. This will be the amended and restated Certificate of Incorporation. Why amended and restated? Well, it's basically saying we're replacing it. You had this short form document, and that worked. When it was 3 founders buying common stock or being awarded common stock, no problem. The very simple Certificate of Incorporation works just fine. But now we're getting into a more elaborated form, and we're going to replace it. We're not going to simply amend it. This is something to look at. There are really 2 ways that you can change a document once it exists. You can amend and restate it, which means you do it all over again. You say, that old document is defunct. This new document replaces it in its entirety. Not only does it amend it, it restates it, and implicit in that supersedes it. A simple amendment would be to say, this original document remains a living, breathing document. It continues to exist, it functions, continues to bind the company, but we have this little amendment that we've made and we've added to it. Now, sometimes you will choose to do that and just go with an amendment approach because you're just changing one small thing. And that can happen here. You know, down the road, maybe we just need a few more shares of preferred stock. And we decide we don't want to amend and restate the whole document. Let's just have a 1-page amendment that changes the number of shares of preferred stock that are authorized. Simple enough. But the changes here are so profound and so existential when we're doing a Series A financing or a Series B financing that if we were to have an amendment that somehow needed to feather into an existing document, it would be very messy and difficult to navigate. So we just do it all over again and start from scratch. It's amended and restated. Most of the action will take place in Article 4. And Article 4 traditionally, in most versions of a Certificate of Incorporation, is where the capital stock is articulated. And what we find in the NVCA documents and what we find in venture capital transactions in general is that Article 4 is where we're talking about preferred stock. And what will be covered there will be liquidation. And we know why that's important, because there are good liquidations and there are bad liquidations. But this is basically M&A transactions. It's also what happens when the company goes out of business and something that's bankruptcy or bankruptcy light, dissolution in that regard. But what we're hoping for, of course, is a good liquidation that comes as the result of a merger transaction or an asset purchase transaction, and these are called deemed liquidation events. And those also trigger the application of these provisions. And as we know, what happens within liquidation, we need to understand, is it participating preferred or is it non-participating preferred? And what are the other specific elements and components that relate to that and tie back to that? All of those characteristics, all of those attributes are articulated in this portion of the Certificate of Incorporation. Again, using language that has come to be accepted as standard. Liquidation. we also cover board rights at a high level. And this is important because you'll see board rights at a specific level show up later. The certificate of incorporation is a public document. This document will be filed with the Delaware Secretary of State's office, and it's available to the world. And you could go right now and go online, and if you're willing to pay money, you can see the current certificate of incorporation, even the historic certificates of incorporation of any Delaware company. So as a public document, we always want to be sensitive to how much particular or potentially private information we're expressing in this document. We need to include enough of the core existential stuff that everyone can lean on that and say, yes, these securities have been properly articulated and bounded with the kind of rights and privileges and attributes that need to be baked into them and consequently need to show up in the certificate of incorporation. But we may draw a line and say we don't want to get into particular identifiable information because we want to keep that private. Board rights, that's a place where that happens. So frequently in the term sheet, it would say something like, after the financing, the board of directors will be comprised of 5 individuals. 2 of the individuals are designated by the holders of Series A preferred stock. So the Series A preferred gets 2. And then it might say the common holders, essentially the founders, get 2. And by the way, of these 2, one of them must be the currently acting CEO, who probably is a founder if you're talking about a Series A. But if you're talking about a Series C or a Series D, it may not be anymore. There may be a professional CEO, so-called professional CEO, who's been recruited. And they would probably say something like the 5th director will be disinterested and independent, will be an outside director, that some combination of these other directors and or the stockholders have some say in identifying and designating and appointing. It will then go on to say, in the term sheet, not only do the Series A directors or Series A preferred stockholders get 2 directors, but one of them is going to be Bob and the other one is going to be Sally. And not only do the common stockholders get to appoint, designate 2 directors, one will be the CEO, of course, and that's going to be Rick, and then one will be the other founder, and that's going to be June. And then the disinterested director, maybe they're going to say, well, we'll figure it out later. That oftentimes happens. You kick the can. These aren't easy people to find, and oftentimes they're not identified at closing, but maybe here they have. And maybe they're like, yes, look, we found Jane, and she's perfect. Well, chances are you're not going to want to include this language in the certificate of incorporation. It's very important. It's crucial. It goes to who is going to be occupying the seats on the primary governance body in the corporation. As we know, with the board of directors, there are extraordinary duties and responsibilities that are laid at their doorstep. And these directors have a lot to do and a lot that they want to do. And if the term sheet has gone so far, and it probably has, to name or at least allude to who these individuals will be, rest assured the parties, the investors and the founders alike, are going to want to make sure that the deal documents set that forth so that there is no ambiguity and there is no debate later, not only how the board is constituted, but who literally is on it. But are you going to want that information in your public document? Probably not. A, it might change. And B, it may just be telling the public a little bit more than you want to tell. Because remember, these companies are still private. They're not publicly held companies at this point that are otherwise filing information and reports with the SEC where this sort of information would be discoverable and available. And private companies like to remain private. And this is something that they're going to want to keep private. So what you'll find in the certificate of incorporation is articulation of this architecture to some extent, but it's going to speak to it at 30,000 feet. And it's not going to get into the details. The details will show up later, and we'll see that in a moment. The other thing that you will see in the Certificate of Incorporation is protective provisions. These are the veto rights, so to speak, the blocking rights that the preferred stockholders have as preferred stockholders. Corporate actions, transactions, acts, which may only be consummated with the approval of the preferred stockholders. Those appear in the Certificate of Incorporation. In the old days, you would have to look around. Sometimes the protective provisions appeared in the Certificate of Incorporation, but sometimes they appeared in a stockholders agreement. Sometimes they appeared in the stock purchase agreement. They could float, because there are lots of ways that you can look at them and think about them. But the general thinking is, and the general point of preference, is that they appear in the Certificate of Incorporation. And they do. And so in the NVCA model form, you'll find those there. You'll also find, and this gets overlooked, but it's pretty important, basic voting rights, which say that, hey, the preferred stock is voting stock, has the right to vote side by side with the common, and it probably says votes there on a one-to-one basis. That appears in the Certificate of Incorporation, and should, because it goes to the basic character of the preferred stock. Another component that you're going to see in the Certificate of Incorporation is anti-dilution protection. And anti-dilution protection goes to what happens if there's a down round. And a down round, of course, would be a subsequent sale of preferred stock at a price per share less than the price at which this preferred stock was issued and sold. So if we sell Series A preferred stock to a venture capital firm at $1 a share, and then 2 years later we sell Series B stock at 50 cents a share, assuming that our deal has anti-dilution protection, and it probably does, it will appear here in the Certificate of Incorporation. And there are, of course, two basic types of anti-dilution protection. There's something called full ratchet, which simply means the price adjusts to what the new price is. So if we sold Series A at $1 and then we sold Series B at 50 cents, we're essentially going to say the Series A is worth 50 cents. And we do that not by issuing more Series A, but by changing the conversion formula. So now preferred won't convert into common on a one-to-one basis. It will convert into common on a one-to-two basis. That's the way that you make up for that economic gap. That's the way that you effectuate the application of the anti-dilution protection. There's another type of anti-dilution protection called weighted average anti-dilution protection, and this is much more prevalent and much more market and much more frequent. It's what you see in virtually every transaction. And fundamentally at 30,000 feet, this is very detailed, but the idea is depending upon how many securities you sell in the down round and how deep the discount is, that will impact how much adjustment is made to the Series A. So if you sell one share of Series B at 98 cents, with the weighted average application, you may not budge that conversion formula off $1 and off the one-to-one, or if you do, it's going to be a distant decimal, as opposed to full ratchet where we go straight to 98 cents. But if you raise $20 million at 50 cents a share, the way the math works is it's going to drive that Series A dollar very close to 50 cents because the discount is deep and you've raised a ton of money. And so the math works that way. Now, what I would add is this is one of the places where the NVCA model documents have saved everyone a lot of heartburn. This is a very math-heavy provision, and it's a very detailed and technical and mechanical provision. And in the old days, every law firm articulated it differently. So when you were company counsel receiving first drafts from investor counsel, you'd need to go find the anti-dilution protection. Probably it was in the certificate of incorporation, but it didn't necessarily need to be. It probably still belonged there even then, but maybe they put it someplace else. So the first thing you might do is move it into the certificate of incorporation if it shows up someplace else. But then beyond that, you had to work through this painfully, line by line, and you'd run scenarios. You'd sit there with a calculator or a pencil or an Excel spreadsheet or whatever you did, and you'd say, okay, if this is the hypothetical scenario, let me plug it in and let me follow the language through and see if it works. And that took time, and then there were many first-year associates, second-year associates, third-year associates whose introduction to these transactions was just running a series of hypotheticals in the investor counsel's articulation of weighted average anti-dilution protection language. We've eliminated all of that because we know it works. Okay, that's why it shows up in the NVCA documents. They boiled it down. It's still very technical. It's still very painful. But you look at it, and if you run your red line and you see that they haven't touched it, you can drive right by it because you know and have confidence that it works. You don't need to do all that scenario working. That saves your client thousands of dollars, and it saves you untold headaches and heartaches. So that shows up in the certificate of incorporation. Finally, just in terms of the big ticket items, if a deal has redemption rights, a put right, that's going to show up here as well in the certificate of incorporation. So what the NVCA did and what they decided is they said, let's take the things that are core to the existential character of the preferred stock security. Does it vote? Yes. Does it have special voting rights? Yes. Does it have board rights? Yes. Does it have some economic rights associated with what happens with the sale of the company? Yes. Does it have some economic rights that help protect it in a bad subsequent financing scenario? Yes. Does it have some economic rights that are associated with the terms and the circumstances and the timing under which they can put their shares back and force the company to buy them out? Yes. Okay. All of these things go to the character and the shape and the personality of the preferred stock security. And as a consequence, we think that that is core, we think it's intrinsic to that security, and we think it should all be embodied inside the certificate of incorporation. So that's the architecture, and these are the provisions that show up there. And as I mentioned, we have language that we've all agreed to, and we've all said this is the way that these should be expressed. That's what you can expect to find in the certificate of incorporation, and it's why it's so important, because these are the meal ticket, big ticket items. This is 90% of your transaction right here in the certificate of incorporation. It's why I always start with that when I'm drafting. It's why I always start with that when I'm reviewing. And it's what you always are going to look to on a going forward basis when issues pop up, because it's always implicated, because it's so important. So that's the certificate of incorporation. The next document is the stock purchase agreement. And the stock purchase agreement is one of those documents that, as I mentioned earlier, was a bit of a wild card. It was a basket where the drafter could put all kinds of things. Whatever they wanted could show up in a stock purchase agreement. It wasn't necessarily limited to one type of issue or one type of matter or one type of term. It could be a catch-all document, and frequently was, and it frequently was a grab bag. It would look really different, transaction to transaction, law firm to law firm. The NVCA looked at that and said, no, we're going to set it up in a very particular way. And what they said was, and this goes to the other documents that are involved in the transaction, said we have time on an axis. And if that's time and it's linear and it's moving left to right, we have this moment here, which is our Series A preferred stock financing. That takes place right there. On that timeline, the amended and restated certificate of incorporation is going to be adopted and implemented and filed immediately before the financing takes place. Why? Well, you can't sell the stock until you have the stock. And you don't get the stock until you actually create it inside the certificate of incorporation. So the certificate of incorporation must be completed and filed and be effective in advance of the closing of the financing, meaning the money is released and the investment is deemed closed, it's done, it's been made. So that takes place immediately before. What takes place here at the closing, what's effective, is the stock purchase agreement. Okay, what's happening with the stock purchase agreement? Well, the stock purchase agreement in the NVCA universe does two primary things. The first thing that it does is logistics. And I can say that generally speaking, it always did that. It was a stock purchase agreement. So it described what's happening. Who's the company? Who are the investors? How big is the financing? How much is each person buying? When are we closing? Is there just one closing or are there two closings? What's the price per share? Are there other elements or conditions that are associated with the closing of this transaction? Whatever is related to the basic technical mechanics of who shot whom and where and how is it all being settled out inside of this financing transaction, those logistics are articulated and laid out in the stock purchase agreement. There's another component of the stock purchase agreement, and those are the reps and warranties. And as we mentioned, representations and warranties are made by the company, and the representations and warranties that are made by the company speak to the state of the company as of the closing, and they pick up anything that's happened in the past. So from the beginning of the corporation all the way through closing, the reps and warranties cover that period of time. Has the corporation ever been sued? Talk about it. Name all the contracts that the company has ever been made a party to. So on and so on and so on. The reps and warranties go through, sometimes painfully, all of the elements which will go to the state of play of the corporation, so that the investor has confidence that the company is what it says that it is, and that they're investing in the right entity that's clean and isn't too hairy and matches up with what they expected to find based upon their diligence effort and what they were told. And it covers from the beginning of the corporation all the way up to the present moment, but it doesn't pick up anything here. Okay? So the stock purchase agreement does not play on a going forward basis. It's frozen in time. And that was intentional. The idea was, let's create a document which speaks to this moment as it relates to the mechanics of the transaction, and speaks to this moment and what came before as it related to reps and warranties. But that's it. No going forward, nothing going forward about covenants or promises that are being made or what we're doing or how things are going to work on a going forward basis. We will handle that elsewhere. By the way, fair to mention that investors make reps and warranties too. The investor reps and warranties are tied 98% to securities laws. In order to make this transaction work under the securities laws, there would have been an exception or an exemption from the securities laws identified and adhered to in order to assure adherence and that the deal qualifies under that exemption. We're going to want to make sure that the investors all show up a certain way. They probably all need to be accredited. They probably all need to be sophisticated. They probably all need to say that they've had access to information, very basic stuff. Those reps and warranties are going to be covered in the purchase agreement as well, but it makes sense because it also speaks to this moment of the closing of the financing. That's what we're trying to accomplish inside the stock purchase agreement. And by the way, not only do we have clarity as to what's included there, and we know what the fence is, because before it was just a mishmash of various items, we know with certainty what we're going to find in the NVCA document. The language is clear. And this is particularly helpful with reps and warranties. And because this piece does get somewhat negotiated Anything, and when you look across the universe of all of these NVCA documents, you can bet that in every transaction, there's going to be some negotiation around representations and warranties. Because every company is a little bit different, and because market does vary a little bit, and frankly, the NVCA documents sort of acknowledge this too, and provide different alternatives and different types of language, noting that some types of language may be more relevant or prevalent or applicable in certain contexts. But not everyone's going to agree about that, and there may be some negotiation. So when I run my red line, if I'm company counsel, I'm going to see the choices that investor counsel made against the form. Which alternatives did investor counsel pick, and then what language that they add. So, if this is a technology or a biotechnology or a life sciences company, I'm probably going to be paying close attention to the intellectual property representation. What did they say? Is it a representation that's going to be very hard for us to make because it involves us making a representation as a warranty, perhaps to things that we don't know? Something like the company's IP doesn't infringe on the IP of any other third party. Well, we don't know that. You can't know that definitively. So the company might say, we're going to push back on that, and we're going to say to the best of our knowledge, or something to that effect. Now the investor may push back themselves and say, we get that you can't know for sure. But if we're allocating risk, and if there is infringement, we think you ought to own that risk, which means you need to make a rep that you may not be able to definitively know or not know whether or not you comply with it. But the risk of breach should sit with you. In this case, the risk of infringement should sit with you, not with us. It's just an example of the kind of negotiation that you might have. But this happens a lot, and you'll find that those do get negotiated. So notwithstanding the fact that the NVCA has cleaned out any confusion around architecture and has helped normalize a lot of the language and the way the language is presented, there's still going to be some negotiation. And the reps and warranties in the stock purchase agreement is a place where you're going to find negotiation. Well, naturally, we have this period of time. What happens moving forward? Well, we know that the certificate of incorporation is going to cover what happens moving forward. And we already talked about that. All those voting rights and economic rights and what have you, those are going to continue to apply on a going forward basis. But we also have 3 documents that cover what happens with the company on a going forward basis. From a governance perspective, from a rights perspective, and how do these show up and how do these lay out? Well, there are 3. One is the Investor Rights Agreement. The acronym you often see is IRA, the Investor Rights Agreement. And the Investor Rights Agreement within the NVCA universe is going to contain 3 primary provisions, and then sometimes it includes another provision. So it's going to include registration rights. And registration rights go to the ability of the investors to force the company to go public, to register their securities with the SEC for sale to the public, and also the ability of investors to piggyback, so to speak, on company registrations. And it's very technical language, and I can tell you that just like anti-dilution rights, anti-dilution provisions, this is a place where the NVCA has saved everybody a lot of heartburn and heartbreak. These provisions frustrate lawyers. They are rarely activated to the extent that they are even triggered, which almost never happens. The language of the provisions themselves is probably not adhered to because the investment bankers and the facts and circumstances at the time are going to say that this just doesn't work. So there's a question as to whether or not registration rights should even exist. And we may find that they wash out of these deal documents over time. There's a lot of momentum in that direction. But for now, they're still there. And your client probably wants them if you're on the investor side. Because, hey, why would you negotiate against yourself and give up something that maybe might, even if it's in an edge hypothetical, will appear? So it's there. But the language is highly technical and very mechanical, just like it is with the anti-dilution provision. And the NVCA has normalized that language and has saved all of us a ton of time and energy. And this was always very frustrating because not only was it incredibly unlikely, and is it incredibly unlikely that the registration rights will be triggered, but as a lawyer, you had to pay very close attention to those provisions. So talk about something that felt meaningless and like a literal waste of time. Now we've avoided that. Thank you, NVCA. So registration rights will appear in the investor rights agreement. Information rights appear in the registration rights agreement. So this shows up in the term sheet and gets translated into the investor rights agreement and says something to the effect of investors get annual financials, they get quarterly financials, they might get monthly financials, and they have the right to generally talk to management as and when they generally feel necessary. Any information rights that have been negotiated, requested, conceded to and for the investors will appear in the investor rights agreement. What else shows up? Pro rata rights. Sometimes called preemptive rights, participation rights. These rights are the rights of the preferred stockholders to participate, to invest in future financings. And generally speaking, they're drafted in a way that the investors have the ability to maintain their ownership percentage. They get their pro rata share of a future financing. So pro rata rights are the right of an investor to participate, to invest in a future financing. And they are generally structured in a way that they have the right to buy their pro rata share of that future financing so that they can maintain their ownership percentage in the company. So I may be an investor and I participate in the Series A financing and I buy 10% of the company. Under a traditional structure, the pro rata rights provision is going to say in subsequent financings, I have the right as the investor to buy up to 10% of that future financing so that if I want, I can maintain a 10% ownership percentage in the company. It's not free equity. Doesn't mean that I get to stay at 10% forever and not have to do anything. I have to invest. I don't get a discount. I have to pay ticket, whatever. But I have the right to maintain that. The company can't simply engage in a financing transaction and exclude me if I want to participate. That's what the pro rata rights would provide. Then the other piece that so virtually every venture capital transaction is certainly going to include information rights and pro rata rights, and 99% of them are going to pick up registration rights as well. There's one more little catch-all here, and we'll just call this covenants. And this sometimes gets negotiated because this is a place where you do see a little bit of freelancing transaction to transaction. And these covenants, these promises, can take a couple of different forms. One form that you may see is that there may be something in the term sheet that says, we've got protective provisions. And the protective provisions say that certain acts, certain actions, certain transactions may only be effected, may only be consummated with the approval of the preferred stockholders. They're fairly limited. It tends to be 4, 6, 7, big ticket, highly material, organic kinds of transactions. Sale of the company, sale of stock, changing the board of directors, distributing money to stockholders, really big ticket items. But as we know, the board of directors weighs in on lots of other issues. And lots of other issues that may not rise to that materiality, although they do weigh in on those issues as well. But other issues of just, strategic importance, but more day to day. And not in every transaction, but in some transactions, the investors will negotiate for some extra rights there. And how does that show up? Well, it basically says, look, here are some actions or acts or transactions that will come before the board. They require board approval to be consummated or to be effected. That's not controversial, that's just the law. But here's the twist. They'll say such approval must include the vote of both of the preferred directors or one of the two preferred directors or whatever ratio they decide. So when you consider that boards usually work on a majority rules basis, if we have that 5-person structure that I laid out earlier, 2 preferred directors, 2 common directors, and an independent director, well, if you don't have covenants of this sort, these 3 could carry the day. In other words, they could approve a transaction which only goes before the board, isn't picked up by general stockholder voting rights, isn't picked up by the protective provisions, and this would be enough. And the preferred directors they would certainly have the opportunity to try to influence the outcome and to speak to it, but their approval wouldn't be required. This provision in the investor rights agreement would say that, yeah, it only takes 3 out of 5, but you need to include one or both of us. And it's a way to ensure, I mean, you can see it, it's fairly obvious, it's a way to ensure that the preferred directors not only have the opportunity to influence the outcome, but they're actually essential to the outcome. And in some transactions, you'll see that negotiated by the investors, and if it does appear in the deal, it'll show up here in the investor rights agreement. The other sorts of covenants that appear are more general in nature. So in the model term sheet that the NVCA also publishes on its website, as well as other people who use other sorts of term sheets, they probably include other sorts of covenants that they want the company to adhere to. The company needs to maintain directors and officers insurance. To the extent the company makes stock option awards, those awards need to be subject to 4-year vesting. Those sorts of things. There might be 1 covenant like that. There might be 8 covenants like that. Those would appear here. Within that bucket, there's another type of covenant, which you see a lot, and it's observer rights. It's where a preferred stockholder says, I may not have the right to designate a director, and I may not be Bob or June on the board of directors, but I'm allowed to attend. I can go to the meetings, I can hear what's being spoken about, I can speak, I can receive information. I have observation rights. I essentially get to do everything that a director does and have all the access that a director does. I just don't have the right to vote. And if there are observer rights, they will show up here as well in the covenant section of the investor rights agreement. So that's the investor rights agreement. Next, and I would say most non-controversially, better, you have the right of first refusal and co-sale agreement. This agreement does one thing, and it puts certain restrictions on founder shares. Sometimes it places those restrictions on preferred stock, but that's pretty unusual. 99 times out of 100, it's limited to founder shares. And similarly, on the flip side, the beneficiaries are the investors. Sometimes the founders or the common stockholders get to be beneficiaries too, but that's pretty unusual. So in other words, 9 times out of 10, 99 times out of 100, 999 times out of 1,000, the restrictions are on founder stock and the benefit flows to the investors. And how does this work? Well, it basically works this way. It says, if the founder wants to sell its shares, the founder can go out and find a bona fide third party to buy its shares. But before concluding that transaction, it needs to come back to the company and to the investors and give them what's called a right of first refusal, which means they can match it. So if I'm the founder and I find someone who's going to buy my shares for $1 million, before closing that, I have to go back to the company and the investors and say, do you want to buy my shares for $1 million instead? And typically the way that it works is the company has the first right, so they can redeem those shares, buy them directly from the founder if they want to exercise this right. The investors have a secondary right. So to the extent the company passes, the investors have the ability to buy those shares. If it works all the way through the process that's articulated, and there are a couple of different ways that this can be structured, but at 30,000 feet, the basic point is, if it works all the way through and the company and or the investors don't elect to buy some or all of the shares, that founder can go ahead and conclude the transaction with the third party, with the caveat that the investors also have a co-sale right. In the NVCA language, it's called a co-sale right. Sometimes you'll hear people refer to it as a tag-along right, and it generally means, in most cases, the same thing. And the reason I call it a tag-along right is you're going to hear something called a drag-along right show up later, and those two concepts oftentimes connect in other transactions, in other worlds, but not in venture. They show up differently. In venture, we call it co-sale rights. And the point would be this. Let's say that my founder made it through, and the founder has the ability to sell $1 million worth of its shares to this bona fide third-party investor. The preferred stockholders could say, that's a pretty good price. We want to participate in that transaction. And so there's a whole mechanism that's articulated in the co-sale portion of the agreement, which says how does that work? How do we break up that $1 million? How do we spread it and share it on some kind of proportional basis among the participating preferred stockholders and the founder who initiated the transaction? Highly mechanical, highly technical, but that's what the co-sale agreement does. It gives the investors a chance to get some liquidity and piggyback on the back of this transaction if they want. Here's the most important takeaway from this agreement. You may practice venture capital law every day of your career for 50 years. And you may never deal with the transaction that applies and complies with these particular provisions and these particular hurdles letter by letter by letter by letter by letter. It's extremely technical. It's very rigid, and it doesn't at all move or flex in the way the real world does. So the question might be, what's the point? And that's a good question. And the point is basically this. It's not so much that the investors are committed to this right of first refusal, or that investors prize this co-sale right. The bigger issue is that they really don't like the idea of founders selling their shares because they're investing in the founders, and they want the founders to be fully locked into this transaction and fully invested themselves in this deal, and not treating it as a hobby or a side hustle or a profession, but they want them treating it as their life and ensuring that they hold on to their stock and have enough skin in the game is a way to do it. Now, in theory, arguably, we could do away with this 25-page agreement and just put in place a blanket restriction, which says founders can't ever sell their shares, or founders can't sell their shares without XYZ approval. You could do that. There's always been a little bit of unease around the enforceability of those provisions in any and all circumstances. There's a sense that stock should carry with it some right of transferability because it's property. And in the larger world, we generally feel like if you own property, part of the bundle of rights that's associated with ownership is the right to transfer it. So can you have a binding 100% of the time restriction and prohibition on the transferability of stock? Well, in this day and age, probably, because we've become much more comfortable with the ability and the right of people to negotiate these sorts of provisions, and we don't feel like we need to, the courts don't need to act as these sort of the custodian or the guardian of people that are engaged in commerce. The notion is, hey, you can do what you want to do. You know, you're grown up, you signed a contract, it applies. And that's true in Delaware in particular. But there's still a sneaky suspicion that there could be a case where a court might say, this particular fact pattern, this particular set of circumstances is one step too far. We think the founders should be allowed to go ahead and sell their stock, notwithstanding this blanket restriction. This agreement is a response to that. This agreement is there to say, look, we're not telling the founder they can't sell their stock. We're simply saying that if they do decide to sell their stock, here's the process, and here's the mechanic. And by the way, so many hurdles, and it's so difficult to do. it's probably not going to work. So then the follow-up question would be, does this literally mean that founders never sell their stock? No. What it means is if they want to sell their stock, they're going to be looking at a provision in the back, which is a waiver, which says, how do I get all of these restrictions and limitations and hurdles and obstacles waived? And it's going to be some combination of the company and some combination of preferred stockholders who have the right to waive it. And that's the way that it typically goes. So if I'm a founder and I want to sell my stock, I'm probably not going to try to comply with the terms of the agreement. I'm just going to cut to the chase, go straight to the board, go straight to the investors and say, look, here's what I want to do. Are you okay with it? And if they are, you'll get the waiver and you'll do it. If they're not, you'll probably negotiate and have a conversation and sort it out and figure it out. So it's an interesting document in that it doesn't really exist to be complied with literally. Instead, it's there to create the context for a conversation under the circumstance of a founder wanting to get some liquidity, a founder wanting to sell some of their stock. And that's all this agreement does, the right of first refusal and co-sale agreement. I said there were 3 agreements that cover this post-closing until the end of time environment or period. There's the investor rights agreement, there's the right of first refusal and co-sale agreement, and then last and definitely not least, there's the voting agreement. And the voting agreement does 2 main things. The first thing that it does is it covers the board of directors. And it binds the investors and the common stockholders who are a party to it alike to vote their shares in a certain way. And that's why it's called a voting agreement. And how does it bind them? What does it require? Well, it says you will vote your shares in a way to ensure that the board structure that was laid out in the certificate of incorporation is actually affected. In some respect, it's redundant. You know, the certificate of incorporation can be seen to speak for itself in many respects as to how the board is sliced and diced. But with something as important as the board of directors and its constitution and then its composition, a little redundancy never hurt anyone. And so arguably this is somewhat redundant, but it's there for a reason. It's because the right and that particular cohort of individuals is so important, we want to be extra sure. But what it also covers with more particularity in a way that's not covered here is it's going to say something like, oh, those 2 preferred directors, here's the deal. One of those preferred directors always gets to be appointed by venture firm A, and then the initial person they appoint is Bob. And the second preferred director always gets to be appointed by venture firm B, and the first director, the first individual that they appoint to fill that spot is Jane. So it gets into the personal issues, but the voting agreement is private. It's a contract. It's not filed publicly, and that's why it shows up here. We could put that in the certificate of incorporation if we want. You can put anything in the certificate of incorporation. Just know that it's public. And this feels a little bit private. It feels like something we want to keep within a contract that's behind the curtain rather than something that we're disclosing to the public. And so it shows up here in the voting agreement. And as a consequence, it's a very important document because it gets into these personnel issues. And if you do this work, what you will find is the voting agreement is an agreement that you touch a lot. You look at the certificate of incorporation a lot. You look at the right of first refusal agreement almost never. You look at the investor rights agreement from time to time, most of the time when you're dealing with a financing and you've got pro rata rights, but you're really into the voting agreement because this board structure is something that's always being revisited and retested, and this includes the real meat on the bone. The other part of the voting agreement, I had a little foreshadowing for this. These are the drag-along rights. So the drag-along rights basically say, and recall that I mentioned that they are a cousin concept to tag-along rights or co-sale rights. So if a tag-along or if a co-sale right gives me, an investor, the right to affirmatively choose to tag along with the transaction. In other words, it's up to me, and I can choose to sell stock alongside a founder and participate voluntarily in that. I can tag along. A drag along says I can be involuntarily pulled and forced to sell my stock. Well, when does that happen? Sale of the company. And drag along rights are there to ensure that all the investors who will be parties to the voting agreement and the common stockholders who are parties, tends to be the founders and the big ticket common stockholders, there's usually a threshold set so established so that you don't need to chase the onesie twosies, but people who have some meaningful meat are going to be asked to be a party to this. If the company is selling itself and the drag along rights are triggered, they will be obligated to participate. They will be obligated to vote in favor of the transaction. They will be prohibited from exercising dissenters or appraisal rights if it's a merger where those might otherwise be triggered. They need to sign the documents that are involved in the transaction. It's a very heavy-handed provision which is there to ensure that nobody tries to create friction or static within the context of an exit transaction. Now, drag-along rights then, importantly, can be triggered in a couple of different ways. There was a time when drag-along rights were first introduced that it was the preferred investors acting alone who could trigger the drag-along rights. And as a consequence, they usually had a time period. It was something like 5 years. So if you're in the deal for at least 5 years and the company hasn't sold yet, we understand that investors need to get some liquidity. So as a consequence, they can say, hey, we're going to go find a third party to buy the company. And if we do that, and if we like the deal, we can drag everyone else along. This was really based in large part to be related to the redemption rights that you might find in the certificate of incorporation, which work the same way. They tend to have a 5-year time frame too. And again, it's about liquidity. If I've been in the deal for at least 5 years and I haven't seen liquidity yet, the redemption rights would give me a chance to sell my stock back to the company under certain circumstances. The drag-along rights give me the opportunity to sell my stock to a third party, okay? Now, not surprisingly and not shockingly, founders weren't fond of that. It was the notion where investors could sell their company out from underneath them without their consent. You still see the structure that I described in the occasional minority case. But what you see more often is a provision which will say the preferred stockholders have to approve it, but so too does the board, okay? So now we've picked up this notion that it's not just the preferred stockholders acting alone, but the board of directors who have fiduciary duties also support this transaction and want to proceed, okay? And in that case, we tend to drop the time period because since we have the board, we're not so worried about the investors acting or behaving in a way that's willy-nilly, and it's less about ensuring preferred stockholder liquidity and more about just maintaining transactional coherence, that we're not going to have people acting up. Now, you might be thinking that the founders would say, well, having the board involved helps, but it doesn't necessarily solve the problem because we're just two people on the board. And what if our two preferred directors plus the independent approve the transaction and we don't? Well, in that case, they're out of luck. So oftentimes you will see founders negotiate the right to have a vote too. So it might say something like the board of directors has to approve the transaction, the preferred investors have to approve the transaction, and the founders have to approve the transaction. So at that point, what you're really picking up are just, kind of people on the edges who may not be actively involved in the business, for whatever reason might resist a transaction like this. And as a consequence, it's again a way to ensure some level of transactional coherence. There's another interesting goal and objective that's served by drag-along rights that has been teased out over the years. And the issue is this. The certificate of incorporation outlines liquidation rights. And it says, in the event that the company is sold, the proceeds of that transaction will be distributed a certain way based upon the rights of the preferred and the way those are articulated. Participating preferred versus non-participating preferred, what's the preference, those sorts of issues. But a liquidation event for purposes of the certificate of incorporation, generally speaking, is limited to a merger transaction or is limited to an asset purchase agreement or an asset purchase transaction, an asset sale. And the reason for that is those are the two sorts of transactions that are controlled by the board. Sometimes they're called statutory transactions because the statute with Delaware corporations, the Delaware General Corporation Law, literally requires the board of directors to approve those transactions. And so the company has the ability, because the board has its fingerprints on it, to control the flow of funds and ensure that they happen in a certain way. There's another way you can sell the company, and that's through a stock purchase transaction. So you can have a statutory transaction whereby the company merges into the buyer. You can have a statutory transaction whereby the company sells all or substantially all of its assets to a buyer. But you could also have a transaction where the stockholders of the company just agree to sell their stock directly to the buyer. That's considered a non-statutory transaction because you don't need the board to approve it. You can just do it. And if you get outside of the board, arguably you're now outside of the application of those liquidation provisions. So you could sort of backdoor or circumvent or perhaps find a way around some of those highly negotiated and highly material terms of the preferred stock, for instance. With drag-along rights, the way you'll see those usually articulated is that stock purchase transactions are pulled into this kind of paradigm by contract, essentially saying, look, we're going to smooth this out. So whether it's a merger, whether it's a sale of assets, or whether it's a stock purchase transaction, which otherwise wouldn't be picked up by this, the liquidation provisions and rules will apply. So the back door gets closed. And that happens through the drag-along rights as well, which is useful. Now, it's incredibly rare that you'd find a scenario in a venture-backed company where the stockholders have coalesced in a way to try to manufacture that kind of outcome. There are so many other limitations and restrictions throughout this family of documents to prohibit, prevent, frustrate that from happening. It's such an edge hypothetical as to almost be negligible. But yes, it's an edge hypothetical, and yes, it's virtually negligible, but it would be incredibly devastating to the basic economic expectations were it to happen. This is just a way to pick it up and just tie that loose knot. So that's it. The certificate of incorporation, the stock purchase agreement, the investor rights agreement, the right of first refusal and co-sale agreement, and the voting agreement. Those are the 5 key National Venture Capital Association model legal documents. They contain all the provisions that you're going to find in a traditional venture capital financing. Those provisions will always show up in the same place, so investor counsel and company counsel alike know where to look and know where to find things. And even more importantly, they are expressed in normalized language, which the industry has accepted and which is subject to very limited change and negotiation. And as a final point on this topic in this episode, if you want to just see a tangible demonstration of the success, it would be this. When I did venture capital financings in the late 90s, early 2000s, before the wide adoption of the NVCA documents, you could expect, for instance, at a Series A transaction, the legal fees would cost somewhere between $20,000 and $30,000. Fast forward to today, 20 years later, the legal fees for Series A venture capital financing are probably going to be somewhere between $20,000 and $30,000. Same price. Okay, well that doesn't tell you much, does it? Well, here's the key variable. Hourly rates have increased 4-fold, 5-fold, 6-fold, 7-fold, 8-fold, depending upon the firm, depending upon the region, depending upon the status of the attorney, since 2000. So if we just would have continued doing what we were doing in 2000, fast forward to today, a Series A transaction, just a very typical plain vanilla Series A transaction, would probably cost $50,000, $60,000, $80,000, $100,000. That's not the case. The price is the same. Why is that? It takes less time. Why does it take less time? Because of the NVCA model legal documents. So incredibly effective, incredibly efficient, and incredibly successful.